Court calls case, People versus Amanda Smith.
All right, folks. Welcome back to Shazi Gavel, where the courtroom isn't just a place for justice. It's a full-blown pressure cooker where excuses get grilled, lies get exposed, and sometimes people walk in thinking it's just another Tuesday and walk out realizing they just played themselves. And today's docket, oh, it's a buffet of chaos. We're starting with Amanda Smith, and right away we've got the classic courtroom combo. A plea deal, probation history, a judge laying down the reality check, and a legal system that does not care how small you think the theft was. Because once you're in the system, every detail becomes a lever that can swing your whole life. But don't get comfortable, because this video escalates. We move from basic plea negotiations to defendants who are literally out here treating court like a calendar suggestion. We've got a dude who apparently took his scram tether and decided to audition for Fast and Furious Probation Edition. Then we hit the New Year courtroom vibe, where the judge is trying to be festive, but the defendants are coming in like, "Your Honor, let me ruin your mood real quick." And wait until we get to the cocaine testing discussion, because Judge Simpson is not buying the "I was just near it" defense.
Absolutely, for the people.
Just on behalf of Amanda Smith. Amanda, would you state your name for the record?
Amanda Smith.
Judge, today's time day for PCC. My client is going to take advantage of the offer offered by Ms. Landy to plead to a no.
I have a plea form that indicates she's going to plead larceny, 200 to 1,000 to 1 year offense. Upon her successful plea to that charge, no contest plea to that charge, count one would be dismissed.
That's correct.
Okay, this right here is what we call the courtroom fast lane. The defense attorney basically comes in saying, "Look, Judge, we're not here to fight, we're here to settle." And that's important because plea deals are how the system survives. Trials are expensive, slow, and risky, so most cases end exactly like this: negotiation, paperwork, and a controlled landing. Now notice what's being offered. No contest to larceny, $200 to $1,000. That's a misdemeanor, but don't let misdemeanor fool you. It can still mean up to a year in jail, heavy fines, and court costs. The big benefit? One count gets dismissed. That matters a lot because every extra count can increase sentencing exposure and mess up your record. And here's the chess move. The attorney mentions probation in another county and says this case happened before that probation, meaning they're trying to avoid this being treated as a probation violation. That's not a small detail. That's the difference between routine sentencing and welcome back to jail. Question for you. If you were Amanda, would you take this no contest deal or risk trial and fight it?
I have a plea form that indicates she's going to plead larceny, 200 to 1,000 to 1 year offense. Upon her successful plea to that charge, no contest plea to that charge, count one would be dismissed.
That's correct, Your Honor.
There is also an indication of no delayed or deferred.
That, for the record, Judge, my client is on probation in Detroit, Third Circuit, but this case had preceded that case, so I don't believe there'd be a violation of that. We've signed a vice rights, and I don't know if the judge sentencing waiver was necessary, but we signed it.
All right. May I have her sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? State your name.
Amanda Smith.
Smith, it is this court's understanding that you are going to be pleading no contest to the charge of larceny, 200 to 1,000. Is that correct? That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property, which is the subject matter of the theft. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, sir.
All right. Do you understand what a no contest plea is?
Yes, sir.
All right. Two things about it I have to make sure you understand. It first means that you're not further desirous or wanting to contest these charges. You understand that?
Sir.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty.
Boom. Judge Simpson just delivered the most important legal reality check of the entire plea process. A lot of people hear no contest and think it's some kind of loophole like, "Oh, I'm not saying I did it, so I'm safe." No, not in sentencing court. Here's what no contest, nolo contendere, really means. You're not admitting guilt in the same way as a guilty plea, but you're also not fighting the charge. And the judge makes it crystal clear. For sentencing purposes, it's basically treated like a guilty plea. That means the consequences are the same: probation, jail time, fines, restitution, whatever the court decides. The big strategic reason defendants choose no contest is usually civil liability. Like, if there's any chance the victim could sue you afterward, pleading guilty can be used against you in civil court. No contest sometimes gives you a little protection there. Judge Simpson also points out that another judge will sentence her, meaning this judge is only taking the plea. That's huge, because sentencing is where things get real. And you can't bank on the next judge having the same mood or patience.
Understand that?
Yes.
You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
All right. Basis for the no contest plea?
A potential civil liability, Your Honor.
All right, ma'am. To this charge, how do you plead?
Contest, Your Honor.
You understand that by pleading no contest, you will not have a trial of any kind. You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
Look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading, you're giving up those rights as well as all the rights on that form. Yes? You understand you're giving up your right to appeal of right.
Yes.
This part is legal seriousness with the volume turned up. Judge Simpson is basically saying, before you sign your life away, I'm going to make sure you understand what you're losing. Because plea deals are not just a handshake. They are waivers of constitutional rights. When she pleads, she's giving up the right to a trial, the right to confront witnesses, the right to force the prosecution to prove guilt beyond a reasonable doubt, the right to call witnesses, and in many cases, even the right to appeal. And that last one, people underestimate it. If you waive appeal, you're telling the court, even if I later regret this, I'm not coming back to undo it. That's why judges go through this checklist so carefully, because if they don't, the plea can be attacked later as uninformed or coerced. Also notice how calm Amanda is. Yes, sir, yes, sir. That's the energy of someone who knows fighting this might make it worse. She's in survival mode. Take the deal, minimize damage, and live to rebuild.
Are you on probation or parole?
Yes.
Pardon?
Yes.
You are, but this offense
Happened way before.
way before
before.
you were placed on
Yes.
probation. All right. Has anybody promised you anything other than what's been stated here today to get you to plea? Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will.
Yes, sir.
Court has been handed and has reviewed Washtenaw County Sheriff's Office report for their case number 2200711121. Any objection to the court having reviewed that report?
No, Your Honor.
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
People are satisfied.
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
February 13th at 10 a.m. before Judge Washington.
February 13th.
All right, here comes the procedural stamp that makes it official. Factual basis found, plea accepted, case moves to sentencing. That phrase, sufficient factual basis, is key, because even in a no contest plea, the court still needs enough information to justify the conviction. The judge reviews the sheriff report, confirms there's evidence, then locks it in. Now notice the pipeline here. Pre-sentence investigation, PSI, gets ordered. This is where probation interviews the defendant, checks history, criminal record, employment, addictions, mental health, basically builds a full profile. And that PSI report can heavily influence sentencing. So for Amanda, the big danger isn't today. It's February 13th in front of Judge Washington. That's where she finds out if she's getting probation, jail, restitution, and/or conditions that will change her life. And I love that the defense attorney says he'll have her contact probation immediately. Because if you ghost probation or delay the PSI process, judges take it personally. It screams, I'm not serious about change. Engagement question. Do you think misdemeanor theft should ever lead to jail? Or should it always be fine/restitution?
In 2025, 10 a.m. before Judge Washington. Bond continued.
Thank you, Your Honor. I will instruct my client to contact probation department 14B.
All right.
Judge, may I have police report back?
See what you gotta do.
Judge, I thought you'd be in a little better mood.
I am in a fine mood. Thank you, Mr. Killawall. You just keep trying to spoil it. Get him out of my well.
I'm trying.
Jesus, just give him his little papers back. Go, just go. Is that your last day?
Yes, I'm out of here.
Okay, good. Now I'll be in a great mood.
Happy New Year, Judge.
And to you, Mr. Killawall. Oh no, but Pellinger's gonna come up. He's gonna just.
I would love one of my cases to be called, Your Honor. That'd be great.
Put it at the bottom.
Oh, come on.
Court calls the case, People versus Thomas Rascal. Yeah, I know what you're trying to say.
Special for the people.
Your Honor, Alexis Plumai, Assistant Public Defender, appearing with and on behalf of Mr. Rastall, who is approaching. Could you state your name?
Thomas, right?
Thank you, sir.
And
You're requesting an adjournment?
yes, Your Honor, we are requesting an adjournment of about 2 weeks. We're still waiting for Mr. Rastall's screening to be completed with the Washtenaw County Treatment Court.
Now we're stepping into a totally different type of courtroom storyline, treatment court. And for a lot of defendants, this is the fork in the road between repeat offender and someone who actually gets clean. Treatment courts are designed to address underlying substance abuse issues instead of just cycling people through jail. But the screening delay here, 3 weeks already, now asking for 2 more, that's where the system starts to look messy. Because if the defendant is sitting in limbo, that delay can cost him housing, work, health treatment, and stability. Judge Simpson is listening, but you can tell he's not thrilled. He asks which court, clarifies the program, and then, here's the key. Bond becomes the battlefield, because if the defendant gets out while waiting, the court risks another relapse, missed court date, or new charge. But if the defendant stays locked up, the court risks turning rehab into punishment. That balance is hard. Question for the audience. Should treatment court screenings happen faster, especially when someone is in custody?
Out of 14A4. It's been 3 weeks since he was referred, so I'm hoping an additional 2 weeks, it'll be done by then.
Which court?
It's Judge Freshour's treatment court. I think it's called Washtenaw County Treatment Court.
Okay.
And Your Honor,
You think too? Okay.
I would like to address bond if I could.
Of course you would.
So, Your Honor,
We do adjourn it, or you want to address bond, or you just want to keep talking?
can we do both?
Whatever you want to do. Go ahead.
Okay, so why don't we get the new date and then?
Okay, let's do that. Boy, she is
I'm sorry, Your
she
Honor.
is awful bossy. Probable cause conference.
Ask him.
You think 2 weeks will be enough time?
I'm in 5 weeks to get the screening done. I hope that would be.
I don't know what the holdup would be. Let's try to be set. Let me give you, I'll give you the 16. See where we're at.
Okay.
9 a.m. Yes, as to bond.
Your Honor, with regards to bond, I am asking the court to consider a personal bond for Mr. Rastall. His bond was revoked 3 weeks ago on December 12th for a bond violation for a positive drug test. At that hearing, Mr. Rastall took accountability for that. He came to court knowing that it was incredibly likely that he would be remanded. He's expressed to me a genuine interest in treatment court and in his sobriety going.
Here's the heartbreaking part. The defense attorney is doing what defense attorneys are supposed to do. Humanize the client. He took accountability. He wants sobriety. He's trying. That's the redemption pitch. But Judge Simpson hits the question every judge has to ask. If I let him out, what will keep him sober? And that question exposes a weakness in the defense argument. There isn't a structured plan yet. No confirmed program, no treatment slot, No verified supervision system except hope. Then comes the medical angle. Major dental procedure, dentures, pain, glaucoma meds. That's heavy. And that's real life. Jail isn't designed to manage health properly, and missing a medical appointment can be devastating. But the judge remembers one crucial thing. Bond was revoked for a positive drug test. So from the court's perspective, though we already tried trust, and it didn't work. That's why the judge says, we already did that though, didn't we? That one line is the entire case in one sentence. This isn't about promises. It's about patterns.
Forward, he
Counsel,
has reliable.
counsel,
Yep.
if I were to let him out, what would be in place that would allow his sobriety to happen?
Your Honor, I mean, he would be doing the screening for treatment court. He doesn't have treatment set up, but what I was going to mention was that the reason he's requesting to be out in part is because he was scheduled for a major dental procedure on the 13th. He's afraid that if he misses that appointment, he'll lose the funding for it. He was due to have many teeth extracted and get fitted with dentures. That's something that's causing him a lot of pain, and he also states that he hasn't had access to all of his medications for his glaucoma while he's in the jail. So he would really like to get home. He has his own apartment. He's got reliable transportation, reliable contact information. He could do the screening out of custody. I understand the court's concern with regards to not having treatment set up yet, but again, just asking the court to consider a personal bond.
We
Mr.
already did
Rascal's-
that though, didn't we?
Yes.
And that didn't work too well.
Yeah.
Response?
Your Honor, we were here on the 12th and defense counsel asked for release at that time and the court wanted the defendant to be screened first. And I think that makes a lot of sense. Unfortunately, with the variety of substances, don't know that we can have testing conditions to ensure public safety and people's minds. I would say that if when Mr. Russell is screened by Mr. T, which I think I'm surprised it's not already been done, frankly, because he's very quick, especially when he knows people are in custody, which you did know at the last time we were here, I believe, if I recall correctly. If he screens Mr. Russell and then want to get a stipend order together for residential treatment or inpatient treatment, the people would be very happy to consider at that time a stipulation.
I'm trying to get outpatient.
All right,
Understood, Your Honor.
all right. So motion for bond reductions tonight. Bond will continue. Thank you. Court calls case, People versus Thomas Elkins.
Mr. Lundy for the people.
Assistant Public Defender, Shazi Gavel, Your Honor, on behalf of Mr. Thomas Elkins, but unfortunately not for Mr. Elkins, Your Honor.
Oh, boy. Here we go again.
First one for the year.
Yeah, but it's just a continuation of the same process, isn't it, Ms. Ekman?
For different. But Your Honor, it looks like Mr. Elkins was originally in custody and he's no longer in the Washtenaw County Jail. I have not been able to make any contact with him.
We'll solve that.
I would be remiss if I do not request an adjournment, possibly, being released and navigate the court system. It's a little difficult.
It does look like the defendant was arraigned on Christmas Day and he got a PR with a scram tether before release. So
He took his scram and ran.
I can see so. I'm gonna request the bench warrant.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 25,000. Cash surety.
Oh my God. He took his scram and ran is one of the most savage lines you will ever hear a judge casually drop. For anyone wondering, a scram tether is an alcohol monitoring device. It's literally designed to detect alcohol use. and courts often use it instead of keeping someone in jail. So this defendant had the ultimate deal: PR bond plus tether. That's court speak for, we'll let you live free as long as we can monitor you. And what does he do? Disappears. No contact, no court, nothing. And the judge doesn't even hesitate. Bench warrant, immediate $25,000 cash surety. That means no sign and go. That means if he gets picked up, he's sitting until someone pays real money. And I need everyone to understand this. When you run like that, you don't just ruin your own bond, you poison the well for everyone else. Judges remember these cases, and then later when another defendant says, "Please trust me," the judge is like, "Yeah, I trusted the last guy and he sprinted into the sunset." Audience, is this stupidity or intentional manipulation?
That warrant will issue immediately. Second ruling. It's just gonna be a long year for her. Court calls the case, People versus Jerry Relaford.
Andrew Childers appearing on behalf of you.
Assistant Public Defender Alexis Plumai appearing with and on behalf of Mr. Relaford. Mr. Relaford, could you state your full name?
Jerry Relaford.
And Your Honor, at this time, I believe our office is still waiting on video discovery on this file. So we would ask for a very brief adjournment.
January 16th, 2025, 9 a.m.
Thank you, Your Honor.
Bound to continue. Thank you. Court calls case, People versus Jalecia Harris.
Ashley Lonnie for the people.
Assistant Public Defender Jay Bellinger on behalf of Ms. Harris.
Is this the one you want to?
I know.
No, is this the one you want to call?
Okay, this part is pure courtroom sitcom energy. But don't get fooled, because underneath the jokes, Judge Simpson is actually doing something strategic. He's controlling the room. Notice how he calls out the attorney for being rushed and emotional about getting the case called. Judges hate being managed by lawyers. They'll allow requests, but the moment they feel like someone is trying to steer the calendar or pressure the bench, they tighten up. And Simpson's style is sharp. He jokes, he roasts, he teases, but it's a warning wrapped in humor. Also, the judge mentioning New Year spirit is important. It sets the stage like, I'm trying to start fresh. Don't make me regret it. And that's why the next moments hit harder, because when you disappoint a judge who's trying to be reasonable, the reaction is usually swift. And this is the psychological part of court people don't understand. It's not only about what happened in the case, it's about how you show up. Respect, seriousness, and responsibility matter.
Is this the one you were in a rush to have called? You don't even have a client. Go ahead, Bellinger.
I knew I was.
He was rushing to have, you know,
I do.
did you see that? This
Your
is
Honor.
how he starts the year off. I had to like pass it and make him sit down and just wait. Like
Yeah.
waiting for his client. But I'm not gonna do that to you.
I appreciate.
I am in a New Year's spirit.
I would ask, and see, I'm not Bob Killawald, and I'm not
Wow.
going to try to put you in a mood.
I know Mr. Killawald. Mr. Killawald's a good friend of mine. You sir are no Bob Killawald. Go ahead.
Your Honor, I have spoken with Ms. Harris this morning. She informed me that she was in the drug treatment court this morning. And/or I have a text message from her, Your Honor, and that says, "Good morning. I am in treatment with Don Farms." She was asking if it was possible for an adjournment this morning on her behalf. I did inform her of the violation. I wasn't aware she was in treatment with Don Farms, Your Honor. I did tell her that she needed to appear because of the violation. I did also talk to her. Go.
Dawn firms will usually arrange to get him here.
Yeah, I understand, Your Honor. I think that because she probably did it this morning, because this is the first I'm hearing about. I talked to her yesterday and she wasn't doing that. She was working with Sparrow only. She may have just admitted herself inpatient in Don Farms. So I don't believe she's going to be appearing today.
This is where court gets complicated, because on the surface it sounds noble. She's in treatment. But court doesn't run on vibes. It runs on compliance. Judge Simpson immediately spots the problem. If she's truly in a structured program, that program usually coordinates attendance. Drug treatment courts don't want participants skipping regular court obligations, because that undermines accountability. So when the defense says she might not appear, Judge Simpson hears, she chose treatment timing over court timing, and that's risky. Also, the attorney admits something huge. Yesterday she wasn't doing this, meaning this treatment move could look like a last-second scramble right after getting hit with a violation. That's where judges get skeptical. Are you actually choosing recovery? Or are you strategically ducking consequences? And Judge Simpson's response, "It was the end before you started," is brutal but accurate. In court, if you don't show, everything else becomes irrelevant. You can have the best excuse in the world, but failure to appear is like detonating your credibility. Engagement question. If someone is in rehab, should the judge still issue a warrant or pause enforcement?
I would ask for an adjournment. Thank you. The end.
It was the end before you started.
come
Go ahead, Ms. Lundy.
You would request bench warrant given her community corrections violations for not going and not testing and out of here.
New Year spirit.
Okay, well, here it is. Bench warrant, $25,000 cash surety. That warrant will issue immediately.
And there it is. Judge Simpson goes from New Year's grace to I'm not playing. Bench warrant, $25,000 cash surety, immediate. That's not just punishment, that's court control. Here's why. Judges have one job above all: keep the system running. If people realize they can just skip court and send a text saying, "I'm busy," the courthouse collapses into chaos. So even if Ms. Harris is genuinely in treatment, the judge is sending a message. Treatment doesn't override court orders unless it's handled correctly. And then we get that extra spice. The judge tells the attorney to say it with more sincerity. That's Judge Simpson basically saying, don't act like this is no big deal. Because bench warrants are serious. They lead to arrests, job loss, childcare disasters, and spirals. And this is the tragic irony. A person might actually be trying to improve, but the way they handle it matters. The court rewards structure, not improvisation. Rehab is great, but not if you treat court like an optional appointment.
Thank you.
Thank you. Great seeing you, Your Honor.
Yeah. Yeah, a little bit more sincerity in your voice. Is that all that you have?
No. Do you want to call my other one so I can get out of your hair? No. I know you.
No, Miss Apple, he's lost his mind. I don't know. Miss Apple, you know how to conduct yourself. Talk to him.
Okay.
All right, thank you. Court does call the case of the people versus Walter Peterson.
Kyle Bradell on behalf of Mr. Peterson, but not with. I have been in contact with him this morning, Judge. Much like the rest of us, I know myself certainly he has lost track of the date. What it was, I told him Thursday, and I know I'm something with myself. So I'm just asking that the court pass the matter. I did call him today. He's on his way.
Ben.
This is one of those moments where you see the gap between real life and court life. Because in real life, losing track of a date is like, oops. In court, that's like telling the pilot, I forgot we were landing today. The attorney tries to make it relatable. Much like the rest of us, he lost track of the date. But Judge Simpson immediately reminds everyone, the court calendar is not a suggestion. If you're charged with a crime, court dates become sacred. And notice how fast the judge moves. Bench warrant issued, $10,000 cash. No debate. Why? Because the court can't gamble on whether he'll show up in 10 minutes or 10 days. He's on his way is one of the most common courtroom lies. Even when it's true, judges have heard it 1,000 times, and so they don't risk it. And this is also retention gold. It reinforces the theme of the day. The judge is dealing with a parade of noncompliance. And every time someone misses court, the judge's tolerance for the next person drops.
Warrant will issue, bond, 10,000 cash surety. Warrant will issue immediately.
Thank you, Judge.
Court calls the case of the people versus Brianna Kingsley.
On behalf of the people. Assistant Public Defender Jay Bellinger on behalf of Ms. Kingsley, coaches, Your Honor. Ms. Kingsley, can you please state your name for the record?
Brianna Kingsley.
Well,
Your Honor, I have submitted an adjournment form to the court. We have some continued negotiations. I did send a mitigation report for review by the prosecution. They're asking for her next pretrial is set for February 25th, 12th. I understand that the court can't go out that far. I do.
well, that's in 15.
Correct.
But as I'm reading this, you're trying to track that case. for
We are
something
trying to
that-
track the cases together too, just to see what's going on in terms of mental health treatment, Your Honor.
Okay, back up a second.
Sure.
Haven't seen Miss Kingsley for a while. Is she in mental health court there?
She is not. She is getting mental health treatment, however, outside of the court.
Got it. And so that's, correct me if I'm wrong, that's being monitored kind of with the 15th District Court case.
That is my understanding.
And you're trying to follow along with some of that information regarding this case.
That's correct, Your Honor.
So why wouldn't I put it out after?
I would be asking for you to. I just didn't know if the court would be willing to do that for me.
You know, Bellinger, sometimes you just have to ask, but you always just ask for the wrong stuff.
Well,
Okay, this is Judge Simpson at his best. Sharp, teasing, but also quietly fair. The defense is asking to line dates up with another case that involves mental health monitoring. And the judge, instead of being rigid, actually works with them. That matters. The court is recognizing something important. When mental health is involved, stability is the goal. If a defendant has multiple court dates in different systems, it becomes harder to comply. And non-compliance makes the situation worse. So coordinating dates is actually a smart move. But the judge wants the attorney to just say it plainly, confidently, and correctly. That "you always ask for the wrong stuff" line isn't just a roast. It's the judge reminding the defense, you're an officer of the court. Be direct. Don't dance around it. Also, Miss Kingsley's presence here gives a different vibe from earlier defendants. She's in court. She's participating. She's being managed by the system. And because she's showing up responsibly, she's receiving flexibility. That's the hidden rule of court. When you cooperate, the court becomes human. Audience question: should mental health treatment reduce penalties? Or should the law treat everyone the same?
All right, this one I would do. This is not a problem. All right, so
Then we're asking.
okay.
what?
Then we're asking.
She got
Well,
this.
I know Miss Kingsley would ask me. I just don't know why you did. Okay.
I was
um,
trying. I was going to get there.
Well, quit taking the scenic route. Um, so your next date in 15th to 12th.
Yes, sir.
All right. So let's go then, so you can figure that out. I won't go to the next date. Let's go to February 20th, given all circumstances.
Thank you, Your Honor.
Honor.
February 20th, 2025, 9 a.m.
Here you go.
I'll do that for Miss Kingsley.
Thank
All
you.
right.
Thank you.
Yes.
Thank you.
Happy New Year. Court calls the case, People versus Eric Mayfield.
Your Honor, Alexis Plumai, Assistant Public Defender, appearing with and on behalf of Mr. Mayfield. Mr. Mayfield, could you say your full name? Your Honor, we are asking for an adjournment here. I would just ask for 2 weeks.
Without objection, January 16, 2025, 9 a.m. bond continued.
Thank you, Your Honor.
No, just- Court calls the case of the People versus Antoine Patterson.
Assistant Public Defender Jay Bellinger on behalf of Mr. Patterson, Antoine Patterson. Your Honor, I have done everything to try to get a hold of my client, less a carrier pigeon. I have not been able to do so, unfortunately. I have reached out to prosecution in order to try and get an offer on this case. Still haven't heard from my client. That being said, I would ask for an adjournment. Am I asking for the wrong thing again?
Everyone objects to that.
No, you're asking for the right thing. Just denied. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash.
This is one of the most embarrassing things that can happen for a defense attorney. And I almost feel bad because you can hear the frustration. The lawyer is basically saying, Your Honor, I tried everything. My client is ghosting me. And Judge Simpson, he's not even mad at the attorney. He's disappointed in the defendant. Because when you hire or get assigned a public defender, that's someone fighting for you. If you won't communicate, you're sabotaging your own defense. Then comes the humor. The attorney asks, Am I asking for the wrong thing again? And the judge says, No, you're asking for the right thing. But then boom, bench warrant. That's the judge saying, adjournment granted, but consequences activated. Also, the judge jokes about adding extra money to the bond. In like, can we make it 10? Want me to add 10? That's Simpson's style. Comedy with a blade behind it. Because bond amounts aren't random. Higher bonds increase the chance the defendant stays in custody once arrested. Ghosting court isn't just irresponsible. It's self-destruction.
Can we make it 10?
You want me to add 10?
No,
Okay.
less 15.
That warrant will adjourn me. Thank you.
Thank you. Have a good day.
Are you done?
I am.
Bye.
Welcome.
Wait till he leaves the room. Court does call the case People versus Levante, Washington.
Public Defender Natalie Pate with and on behalf of Washington, who is approaching the podium. Please state your name for the record, sir.
Levante, Washington.
Thank you, sir.
Thank you, Your Honor. As to the probable cause conference, we are respectfully requesting a very brief adjournment. And we do understand that Mr. Washington was asked to be in person today because of the progress report that was sent out. And we also willing to address that one, whoever the court would like.
Why don't you go ahead and address that?
So as the court is aware, Community Corrections did send out a progress report. Mr. Washington did test positive on both 12/27 and 12/30 for cocaine. He did already send out the 12/27 sample to the lab for confirmation. We have not yet received the results from the lab one way or another. He does plan on, after court today, appearing in Community Corrections to have his most recent test sent out for confirmation from the lab. He had planned on doing that today in any event. However, as to the progress report, we're asking the court to hold it in abeyance until we get those lab confirmations back, whether or not that was a positive test. Mr. Washington does deny any use. He is here today with his mother, who I have also had the opportunity to speak with. He resides with his mother, and his mother also says she doesn't know him using. Of course, she's not with him all the time. However, Mr. Washington does deny use. That's why he sent it out to the lab. So we're just asking the court to hold this in abeyance until we get that confirmation one way or another.
And then if it comes back positive, what do you think I should do?
I would ask that that be addressed at that time.
So you just don't want me to lock him up today?
Certainly not today, Your Honor. Mr. Washington appeared knowing that that was quite frankly a possibility. He's staying on top of this, continued to test even after he did get that positive result, went to Community Corrections and paid the $30 to have that sent out.
You going to have a test today?
Yes, he's appearing. He is going to go to Community Corrections after court today to have his test from the 30th sent out, and I believe also to be tested again.
Why do I have the feeling I'm not being told the truth? I've got 2 tests back to back with cocaine. So let me ask this question. If I send you over today and I get those results immediately, is anything going to show up in your system?
No, Your Honor.
Pardon?
No, Your Honor. Like I say, I got a lot of stuff going on for myself. This is not the only, this is probably the least case that I'm worried about. I'm on GPS tether.
WABU, this is where the courtroom turns from paperwork to pure tension. Judge Simpson is basically staring into the soul of the defendant and saying, I don't believe you. And it's not emotional, it's logical. 2 back-to-back cocaine positives is not an accident. Not a one-off, not oops. And notice how quickly Mr. Washington tries to pivot. I've got a lot going on. This is the least case I'm worried about. That's a dangerous statement in court, because judges hear that as disrespect. This case doesn't matter. Also, Simpson's key concern isn't attendance, it's truthfulness. He even says it, I'm worried about your using and then lying to me. Courts can work with relapse. They can't work with dishonesty. Then Mr. Washington says something important. He wants to speak privately because he doesn't want to put people on Front Street. That's basically him implying there's more to this story, maybe involving other people. That can be real. But to the judge, it can also sound like, let me tell you the truth off camera so I can still deny it publicly. Audience, do you think he's lying, or do you think there's a legitimate explanation?
I don't have no reason to run or no reason to not show up and come back to court.
That's all fine. I'm more worried about your use at this point.
Oh no, I don't use at all. I'm not trying to pit everything. I don't know. If we can speak privately, then I'll be able to tell you exactly what's going on, but I don't want to pit everybody on Front Street. That's it, in the courtroom.
So, did you read over that progress report?
Me?
Yeah, because I'm getting a lot of people that are amoebas.
Yes, I did read over the progress.
They're absorbing cocaine. And I'm not sure how that happens. Young lady appears at community corrections, said, I smoked it around him. That must be how he's testing positive. You believe that? Hold on, no. You believe that?
Yes, Your Honor.
Really?
That's the truth.
Counsel Pro, you might want to just be quiet because
I'm sorry. Amoebas absorbing cocaine is absolutely insane. Judge Simpson is done. Cooked, fried. He's heard every excuse in the book, and now he's watching the defendant and attorney attempt to serve him a brand new one. Secondhand cocaine exposure. Now, legally speaking, drug tests can sometimes be contested. Chain of custody issues, lab errors, false positives in rare situations. But cocaine positives like this typically don't come from standing near someone who used. The judge's reaction is exactly what the public is thinking. You believe that? And the warning, you might want to just be quiet, is huge. That's the judge telling the defendant, stop digging. Because in court, the more you talk, the more you contradict yourself. And contradictions are fatal. Judge Simpson also says something key. He hates people not telling the truth. Why? Because probation and bond conditions depend on honesty. If a judge thinks you're lying, the judge stops offering flexibility. This moment is the dramatic peak, and it's about to explode into consequences.
the thing I don't like a lot are people that aren't telling me the truth. Because you can go play your game anyplace else. You're not playing it here with me. Counsel approach.
Good morning.
Miss Senda. Anything else you want to say?
Nothing.
I'll give him one shot. You want to tell me? I mean, from what I understand, he comes over from another place. He's in our jail, gets out, and is saying he wasn't using. I got 2 tests.
I understand that, Your Honor. I would just reiterate my request to hold this in abeyance until the lab confirmation comes back one way or another, and to address it at that time. If in fact the lab confirms that it was a positive result, I would ask for that, Your Honor, and I have nothing further to add. But except that Mr. Washington, I do truly believe will be in attendance to its next future court
I'm
date.
not so much worried about his attendance. I'm worried about his using and then lying to me. That's what I'm worried about. And then getting other people wrapped up lying. You're not an amoeba. It's not going to be in your system for 6 days, at least, in this way. Anything else?
Nothing further from me, Your Honor.
I'll grant the adjournment, and maybe, I would have normally, under most circumstances, put it out 2 weeks, but I'll put it out 1 week to the 9th, 2025, 9 a.m. At this point, however, the defendant's bond is revoked. Defendant's remanded.
Thank you, Your Honor.
Court does call the case of People versus Daniel Magoo.
Actually, let me.
Danny Magoo.
Ready for preliminary examination, or at least to deal with his motions? What are we doing?
Yeah, would the court be so kind as to make the self-representation inquiry? And
Yes.
perhaps we could look at the motion first.
Mr. Magoo, you are here before the court. You're set today for a preliminary examination. You're here before the court on the charge of resisting and obstructing a police officer. That's a felony punishable by up to 2 years incarceration, $2,000 fine plus court costs. You appear here unrepresented as you have in the past, and the court has given you the admonishment regarding self-representation. Court is clear, does believe that you do indeed understand the charges as well as the maximum penalties. There are certain dangers in representing yourself, and it can be fraught with some difficulty. However, I would indicate to you that you are absolutely constitutionally entitled to represent yourself if you so choose to do so. I will treat you no better, no worse than a licensed practicing attorney, but that also means that I will not show any favoritism. You are to also understand and know and operate by the Michigan Rules of Evidence and Michigan Rules of Criminal Procedure. If at any time during the course of these proceedings you decide that you wish to be represented by counsel, cannot afford to hire counsel, then the attorney will be provided to you. So that we don't get into a thing, I am going to assume, unless you say something different, that you understood everything that I just said. Hearing nothing different, what are we doing? Sir, do you wish to be represented by counsel? I guess I'll ask that.
I do not.
All right.
Thank you.
What are we doing?
I think defendant has a pending motion.
Yes, go ahead with your motion, sir.
Still waiting, motion to compel the officers. I thought I'd be here today to speak with them on the record. It's what I've been requesting since my arraignment.
I know, but you requested a deposition. That wasn't going to happen. So what is it you're looking for the court to do?
Your Honor, I'd like to speak with the officers on the record. I've been requesting this since I'd like to.
So do you want to have your preliminary examination? Is that what you want to have?
Yes, Your Honor.
All right.
Sorry.
Is there a response from the people regarding that?
Your Honor, that is one part of the motion.
I know.
And so as to that part, people will be requesting an adjournment of the preliminary examination today as the officers are not here. But as to the other pieces of this, that there are many more things. I did file a written response, which I'm happy to rely on, unless the court has specific inquiries placed to make of that is not sufficiently flushed out.
All right. Sir, what about the other part to your motion?
Is that in regards to waiving my bond conditions? Which part are you referencing, sir?
It's your motion. You go ahead. I will rule on that part. What other part of your motion do you want the court to deal with?
To waive all bond conditions, leaving the state. And I'd like to get the officers on record. That's really what I've been wanting to do. I thought that's what I was here today. I was prepared to do. Your Honor.
Do you have all of the discovery?
I was just submitted an audio file this morning, Your Honor, from the prosecutor. However, it must be corrupt or something. It's not going through. I'm trying to get a valid copy from her. But other than that, I believe I do.
That's correct, Your Honor. We did send over an audio file this morning, and I did see the defendant reply that he was having trouble playing it on both his laptop and on his, I will note it, I'm just seeing today, it looks like the defendant may have a MacBook. And I know that those can have a little bit more of a difficult time with some of the audio files that come from my office. So that may be something that, I don't know that the file is corrupt. I think there's just an issue playing the audio.
Got it. And this is a audio of?
I believe it's the 911 call that brought the officers to the scene,
Okay.
but it would not be an exhibit that people plan on playing at the preliminary examination.
All right.
I would like then to motion for a preliminary examination to get the officers in here on the record, then, Your Honor, please.
All right. Is there anything else you needed the court to deal with? You mentioned bond conditions. You say you have all of the discovery. There may be an issue with the playing of this one audio. Is that correct?
That's correct.
Anything else you're requesting?
No, Your Honor.
All right.
At this time.
With reference to the bond conditions, all of the bond conditions are standard bond conditions issued in every case. So the defendant's motion to change his bond or the conditions of his bond is denied. The court does deem them appropriate and properly set by the magistrate, does not see an abuse of discretion regarding that. With reference to the court doesn't have to deal with any of the discoveries. We have it with reference to the preliminary examination. I'm more than happy to give a preliminary examination date. I will grant the people's request to adjourn in this matter and would set it for the 21st, if that will work with everyone's schedule.
January 21st?
Yes.
That's fine for the people.
Fine for the, Your Honor.
Yes. So preliminary examination will be set January 21st. 2025, 9 a.m. before me. That's in person. Defendant's bond with conditions is continued.
And this is where Judge Simpson drops the hammer. Bond revoked, defendant remanded. That means Mr. Washington is going into custody today. Not because the judge wants to be cruel, but because the court believes two things are happening: drug use and dishonesty. This courtroom session gave us a full cross-section of how the justice system works in real time. We saw a clean plea deal with Amanda Smith, structured, informed, and processed professionally. We saw bond violations and treatment court delays where the court had to choose between compassion and public safety. We saw repeated failure to appear situations where judges respond with immediate warrants, because without attendance, the legal system collapses. And finally, we saw the most serious theme of all: truth matters more than excuses. Because the court can manage mistakes, but it cannot manage manipulation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.